Yeah, I can't explain what implied consent means, but I'd first say to understand implied consent, you have to understand in Utah how a DUI works. And briefly, it's a very complicated system, but every DUI gets separated on a two-track course. There's an administrative course and the criminal course. The criminal course goes through the criminal courts, and people generally understand at least what the system is. But what people may not understand is the administrative nature of a DUI charge. The Utah Department of, or Driver's License Division, as part of the Department of Transportation, can themselves suspend licenses and do without going through proper court proceedings. The implied consent law relates directly to that because it goes to the heart of the issue in Utah and in other states. That is, driving is not deemed a right, but a privilege. While that may seem antiquated, especially given the importance in Utah being able to drive to work, to drive to stores, to drive to social outings, it's still not considered a right, but a privilege. Given that it's a privilege, in order to get your license and in order to be able to drive, you have to agree that any officer can test you. As long as they have reasonable suspicion to believe you're doing something wrong, they can test you for alcohol or any drugs in your system. That consent given when you get your license is called implied consent. So by driving on the road, you have implicitly given your consent to be tested anytime you're in that car. It becomes an issue in the Driver's License Division hearings because whether or not you actually gave consent and whether or not it was valid is not important to the Driver's License Division. They just want to know if the officer had reasonable belief or reasonable cause to believe you were driving while under the influence of alcohol or any drug.